We not see this one coming. No. Now they cannot go report federal high court judge to the appeal court. He say me they stop the man. Remember say, now 20th of this month, now Justice James Omotosho talk say he go pronounce judgment on Nnamdi Kanu's case. Kanu don file motion to stop judgment in terrorism, the cable, Sahara, everywhere. This news dey there. Wetin we go use for this analysis is coming from Sahara reporters. I don break am down. Wetin Kanu want? Why he report the judge? Say make dem stop am o. Egba mi o. If dem no stop am, hey, everywhere go red o. Make we see wetin he talk. What happened? The detained leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, filed a motion on notice. We are going to see the meaning of this. Motion on notice. On Wednesday today, November 12th, 2025, before the Court of Appeal in Abuja. What is the meaning of motion on notice? Motion on notice. A formality request. You use your hand right hand as part of the case. You write hand, okay? Made to the court. You go write hand, go give court. Which must also be shown to the other party, the person where sue you or the person where you sue, before the hearing, before the final hearing, when they walk here. For instance, on the 20th of this month, now he write this motion on notice. He tells them what the applicant, that is Kanu, wants. What is asking the court to do? Okay? He's asking the court to issue a stay of further proceedings. We are going to check the meaning of this. A stay of further proceedings. In his trial before Justice James Omotosho of the Federal High Court Abuja. Okay, what is the meaning of this? Stay of proceedings means a temporary stop or pause in the trial until another court. In this case, the appeal court. Another court. Remember, Federal High Court, then appeal court. Now they higher. Write it to appeal court to stop this one until they judge the matter wey wan tell them about wetin this one dey do. Okay? A temporary stop or pause in the trial until another court, in this case the appeal court, decides an important issue raised by the applicant. Here, Kanu, related to the case or to a case. What is he asking the appeal court to do? Wetin Kanu dey ask the appeal court make they do for am? Kanu filed the application by himself, but no be go give them. He filed it through his lawyer, Barrister Alo Ejimako. He wants the Court of Appeal to stop Justice Omotosho from delivering judgment on his criminal case that was scheduled for November 20th, 2025. As they stand so, okay? He's praying the court. He's begging the court, meaning he's formally asking the court to stop the lower court from proceeding until his appeal, wetin he write to the appeal court, is heard and decided. Okay? The exact request, wetin he dey ask? Make we check the exact request. In his application, Kanu asks for an order saying the proceedings of the trial court in case number this, Federal Republic of Nigeria versus Nnamdi Kanu, currently pending before Justice James Omotosho, pending the hearing and determination of the appeal pending against his decision. What is the meaning of this order? We need to check some sentences here like this. Order, pending, to know their meanings. Order here means a legal direction or command given by a judge. The judge should order them. Pending means waiting for a decision, may they decide. So Kanu is saying, pause this case. You have the power, appeal court. You have the power to stop James Omotosho of the lower court, Federal High Court. Pause it, pronounce it, say me they stop until the higher court decide on my appeal. I get something where the appeal for wetin he wan pronounce judgment on. You get the point now? He mentioned three key complaints. One, the court decision or the no case submission. No case submission. We are going to check it now. No case submission. No case submission means a claim by the accused that the prosecution has not provided enough evidence to justify continuing the trial. Kanu is saying the federal government of Nigeria, there is prosecutor, has not provided enough evidence to justify continuing the trial. Continuing the trial till 20th when they want pronounce judgment. They have not actually provided enough evidence to continue this trial. That's what Kanu is saying. 2. The court's refusal to determine its jurisdiction. What is that? Jurisdiction means the legal power of the court to hear and decide a case. Kanu not tell the court, say, see, as far as you are concerned, you don't have the jurisdiction to try me. But they never really decide on this jurisdiction. Kanu is now appeal to the upper court that the court's refusal, they refuse to determine if they have the jurisdiction to try him. You get the point now? Thirdly, and the validity of the counts. We're going to check the meaning of that. The specific charges, order which is being tried, and the court's foreclosure, we're going to check this, of his right to defend himself by feeding witnesses. What is that? Counts here means the individual charges. Charge 1, charge 2, charge 3. What do you do? What do you do? Your offense. Okay? Listed in the indictment or charge sheet. Okay? The validity of the counts, the validity of the charges, the offenses. How valid are they? Okay? Order which is being tried. Because now the charges that they use to try person are being order which is being tried. Of his right to defend himself by feeding witnesses. Foreclosure here means, remember, we saw it. And the court's foreclosure, aside this, the court foreclosure of his right to defend himself, they stop his right to defend himself. That's what he's saying. Foreclosure here means the court close or block his right to have, in this case, to defend himself. They block me from defending myself. Feeding witnesses means calling people to testify in your defense. Now that you understand this, let's go back. I believe you understand it now. Listen very well. And the validity of the counts of the charges, are they valid? The specific charges, order which is being tried, and the court foreclosure of his right to defend himself by feeding witnesses. Okay? They stop him from feeding witnesses. Remember the last time we checked this? They give a chance. 1, 2, 3. How many days? He say they must tell her whether they get the jurisdiction and order which law are they trying. Say the law where they take right the charges don't die. The judge no great talk put those ones. He say he go still pronounce judgment on the 20th. Kanu is now writing to the appeal court. Now see, they stop me from defending myself because Kanu is saying until you tell me these two, jurisdiction, the law that backs the charges, I no go do anything. And the court no agree talk those ones. They say they won't pronounce judgment. Kanu is now conclude that I don't close my right to defend myself. You see, and so according to the report. 4. His main complaint, the main complaints. Kanu said that even though he raised important jurisdictional questions, the court refused to give a ruling on those points. He said he raised important questions on the court's jurisdiction, but they no agree talk for that one. Okay? Meaning, he questioned whether the trial court, the court, had the legal right to handle his case. They no talk put seed mouth. He also said the trial judge refused to evaluate the evidence given by the government witnesses. The government, they brought witnesses that the trial judge here, Justice James Omotosho, according to Kanu, refused to evaluate the evidence. The evidence when they bring up, he not evaluate them, so evaluate them. Okay? Evaluate the evidence given by the government witnesses in comparison to the cross-examination questions. Meaning the judge should have checked whether the prosecution's evidence was weakened or discredited during cross-examination. When did they cross-examine the witnesses? Now the judge for decide on the evidence of the prosecution or the prosecutor. Okay? Now during that time, say they no do one. Okay? 5. On his defense. Kanu explained that he had already submitted a list of witnesses he planned to call to defend him. He know they run away from this thing. But now those things were he raised, now he stop him. You get the point now. He told the court he was ready to start his defense. So he told the court he was ready to start his defense. After the judge first decide, make you first decide whether your court had the jurisdiction and whether the charges were valid. These two things. Saying, I already prepared my witnesses. We are what call. I'm ready. But there were two things that stopped me. Those two things were not addressed. It's like he placed a demand before he will continue. But the judge refused to answer them, saying, since no one continue, I will pronounce judgment on the 20th of this month. See how so? He can't go report them now. They do like that. However, the trial court, according to him, refused and said those issues where he raised, would only be addressed at the time of judgment. See, so Kanu said, answer these two questions. Once you answer them, then I will bring my witnesses and defend myself. The court said no. Those things you raise, we will talk about them during judgment. When I will pronounce judgment, and that same day, that same time, now we decide them. Kanu say no. Before that day, decide them first. May they clear the way for me to start my defense. You get the point, man. I want to make you understand. Don't say me, I like teaching. His complaint about fairness. Kanu said the trial court, by refusing to rule on his objections, Kanu's objections, those two he raised, has foreclosed or blocked his right to defend himself against the news allegations, very serious criminal accusations brought by the federal government against him. By refusing to rule on those two key points where he raised, they are blocking my way of what? Of defending myself against these dangerous, magnificent, serious criminal accusations against me. The case was then adjourned, meaning postponed to November 2025 for judgment. They say now this day, they go pronounce everything. Hope you are getting it. His fear. What is his fear? From the report, Kanu warned that if the appeal court does not stop the trial court, he might be unlawfully convicted. Unlawfully convicted, meaning found guilty without a fair process. That is why I did report the lower court to you. Because he was not allowed to confirm whether the charges were valid. The court authority, that is second one, that is one. Second one, the court authority, jurisdiction, was not confirmed and it was not given a proper chance to defend itself because these were not cleared. They did not give me opportunity to defend myself. 8. Legal reason. He also argued that continuing the case will suppress his right to appeal. Assume say on that day they convict me without this be addressed indirectly, he go suppress his right to even appeal because even after the federal high court don't place judgment, say you are guilty, for instance, we don't know which they go talk, he can still appeal. He said, if you allow it to continue, man, now the suppression of my appeal be that to my right to appeal. Now in the talk so, okay? Meaning it will spoil or frustrate his ability to challenge the trial court's actions, okay, in a higher court later, okay? He used the term fait accompli. This is a Latin legal phrase, meaning something already done and cannot be undone. Something already done. If you allow them to continue, once they pronounce that judgment, it will be difficult to be undone. Cannot undo it. In short, if the trial goes on, a judgment is given, his appeal will become useless because the damage will already be done. Get it now. Go and read it. Now, the final argument. Kanu said that stopping the trial now will not hurt anyone. He said, oh, appeal court too. If we not stop the trial now, looking at this point where I don't raise my concern, my complaints, it no go hurt anybody. Not the government and not the court. No go hurt the government, no go hurt the court. Why? It doesn't because the case though they ceased 2015 and was only revived in 2025. Why hurry? I'm ready to stay in DSS. No go hurt me, no go hurt the federal government, no hurt the court. I beg, stop him. Finally, he concluded that granting his request will be in the interest of justice. If you grant my request, that is on the interest of justice. Say, you do the matter well. Meaning it will help ensure fairness and prevent harm to his legal rights. And the matter, when Mazi Nnamdi Kanu carry, go tell appeal court via his lawyer, Allah, say, I beg you, the one convict me of failure, come to my head, begin deal. What do you think? You could drop off a comment section. Don't forget to like, share, and subscribe to this channel. Thank you.